the docket. And the fourth case is Gary Kamin and Andre Kamin versus City Mortgage. Good morning, Mr.
Good morning. May it please the court. I'm Mark Stopa, counsel for the appellants. I would request 4 minutes for rebuttal.
4 minutes? Very good, sir.
Thank you. This is an appeal from a summary judgment of foreclosure in an unusual posture in that the lower court granted summary judgment prior to my client's filing an answer. And I say the posture is unusual because case law makes clear that it is an exceptionally high burden that the plaintiff must overcome in order to prevail on that fact pattern. And that burden was not satisfied here. To quote this court in John Jocks, a second district decision from 2010, when we're in this procedural posture pre-answer, the plaintiff must, quote, make it appear to a certainty that no answer which the defendant might properly serve could create a genuine issue of fact. This court ruled the same way in Verizon, also 2010 decision, and there are many others as well. I found it odd that in the answer brief, my opponent on page 22 tries to assert, quote, there's absolutely no requirement the bank disprove the affirmative defenses that Kamin could have brought. Now, it provided no case law in support of that proposition at all. We've presented legions of cases, I shouldn't say legions, there are many cases in both the initial brief and the reply brief which support the proposition that I've stated. They have to conclusively disprove any affirmative defense that we might possibly have raised.
Actually, Mr. Stopa, the case law says is for they have to disprove any material issue of fact, not, as you categorize it, any and all possible affirmative defenses that could be raised. So there's a distinction between the two. You're correct that there's case law that say that based on that they have to make sure that there's no genuine issue material fact that could be raised. But I think you're making the leap to any and all potential affirmative defenses that could be raised. So I just want to make that distinction.
Okay, I think I understand what you're saying, Your Honor. I submit that doesn't create a distinction in terms of how this ruling should come out because they did not prove what they needed to prove. For instance, in their motion itself, there's no mention of any possible affirmative defenses or any possible issues that a defendant might raise in an answer. And that, to me, is the point, is that when you're moving for summary judgment as a plaintiff before the defendant has filed an answer, you have to disprove any possible issues of fact, including any possible affirmative defenses that might be raised. And their motion does not even mention any possible affirmative defenses at all. This court wrote 2 decisions on that issue in Young. I prevailed in 2016, and that cites the Amstone decision, which Your Honor wrote earlier that year as well. Both of those cases talked about the need for a plaintiff moving for summary judgment to address affirmative defenses in the motion itself, as opposed to arguing at the summary judgment hearing.
No, and that's correct, Mr. But those cases, as you know, those affirmative defenses were raised. And what we've held in those cases that it had to be addressed by the court, and the court could not just simply grant summary judgment without addressing those affirmative defenses. So you're absolutely correct on that. I think here you're making the leap. You're making a huge leap in terms of trying to find or trying to anticipate any and all potential affirmative defenses that could be raised. And maybe you and I are talking about the same thing, or maybe you and I are looking, but I just want to make that clear that those other cases are distinguishable because those were raised. Those affirmative defenses were in fact raised.
Sure, and the distinction is, as I see it, is that when you're moving pre-answer, you don't have to, when you move post-answer, you have to address the defenses that are raised. When you're moving pre-answer, you have to address the defenses that could be raised.
Well, and here's what's, let's take that, ad absurdum. I mean, there's a wonderful book of Florida civil causes of actions that also includes lists and elements of all potential affirmative defenses. Is it your position, your argument, that a plaintiff moving for summary judgment pre-answer has to definitively disprove every single potential civil affirmative defense that could be raised?
Well,
latches, accord and satisfaction. I mean, you just go A to Z. Do they have to disprove every single one of them?
I mean, when you word the question like that, it sounds preposterous the way you word it.
But I'm getting a proposed categorical rule that sounds like that's what you got to do.
Well, I'd answer that by reading to you the way this court held in John Jacques, a foreclosure case with this same posture. Plaintiff must, quote, make it appear to a certainty that no answer which the defendant might properly serve could create a genuine issue of material fact. Now, that means, as I see it, that if a defendant could assert an affirmative defense in the answer that he hasn't gotten to raise yet, that the plaintiff has to disprove that issue, because there's no way to reconcile the holding in John Jacques or Barizzo, which followed it, with a contrary position of, well, they don't have to disprove affirmative defenses.
I think there could be, though, right? I mean, you could base it, you could capture it and cabin it based upon what the summary judgment evidence is that gets presented in the motion for summary judgment, what gets then presented in the response to the motion for summary judgment. Okay, so here's the boundary of evidence that we have. What are the conceivable affirmative defenses that one could fashion from this? And that at least gives us something of a boundary as to what it is the plaintiff that moves for summary judgment prior to answer has to disprove in terms of potential affirmative defenses if we were to go as far as you suggest.
Here's the way that I see this. When there's already an answer filed, the conceivable affirmative defenses are spelled out in the answer.
They are what they are.
It's a higher burden before an answer is filed if a plaintiff wants to move for summary judgment. And why is that? To me, that's because the defendant hasn't spelled out what their affirmative defenses are yet, and so the plaintiff has to disprove any of the defenses which might be raised. And to the extent that Your Honors aren't immediately agreeing with that statement, submit if you look back at that quote, must make it appear to a certainty that no answer which the defendant might properly serve could create an issue of fact. Now, we all agree that affirmative defenses create issues of fact where they're not disproven. So to me, that necessarily means in John Jacques and Barizzo that an affirmative defense which a defendant might raise but hasn't yet because hasn't had the opportunity to do so, that it is the plaintiff's obligation to disprove that issue. Were you to disagree with that, then you're necessarily giving the plaintiff a lower burden when they move for summary judgment before an answer than you would be giving them if they move for summary judgment after the answer. Because after an answer, you're forcing the plaintiff to disprove the affirmative defenses that are raised. If you don't force that same obligation before an answer, then it's like you're allowing a plaintiff to get away with not disproving any affirmative defenses at all, even when the defendant has an opportunity to raise them. And I submit that that's why the standard is so onerously high, and the case is treated as onerously high, is that the plaintiff wants a sort of a quickie summary judgment before a defendant's even had gotten a chance to answer. That's why you have to make it appear to a certainty that there's no answer the defendant might serve that would create an issue of fact, and that, I submit, necessarily includes affirmative defenses. I believe that's why Barizzo ruled the way that it did as well, Mitchell, all second district cases which we've set forth in the brief, and I think it's telling that my opponent cites no contrary cases. What's the quote that I read you on page 22 of their answer brief, where they say there's no requirement the bank disprove affirmative defenses the Kamins could have brought? They don't cite any case for that proposition. So I'm trying to understand the distinction that Your Honor was seeing, but as I see it, when a plaintiff must make it appear to a certainty that no answer the defendant might raise could create an issue of fact, that necessarily means that they have to disprove any affirmative defenses. Now, as a practical matter, I'm not here saying, in a foreclosure case that they have to conclusively disprove a seatbelt defense or something that obviously wouldn't apply in this type of case, okay? But anything which might possibly apply in a in a foreclosure type of case, like, payment or waiver or latches or standing or things like that, anything, or what I call estoppel, bank-induced default, any of those types of things which we would consider traditional affirmative defenses in foreclosure cases, paragraph 22, conditions precedent, are all things that they have to prove and disprove in order to get summary judgment before we file an answer. There's no way to reconcile the cases with otherwise. There's no way to read the case law otherwise. And there's no case, and I submit if you ask them, well, what's your case that supports the proposition that they don't have to disprove possible affirmative defenses? They won't have one because there isn't one that exists. And maybe the cases aren't worded in terms of disproving of possible affirmative defenses, but when they're worded in a way that say, make it appear to a certainty that no answer the defendant might serve could create an issue of fact, you're necessarily saying the same thing. So I submit that that is what just jumps off the page in terms of why there should not have been a summary judgment at this stage of the case. Now, in addition to that, you have with respect to paragraph 22, just on that one particular issue. There was no competent summary judgment evidence that the default letter was actually mailed. Traveling under this court's...
Mr. Stoppen, following that, we have no transcript in this case, correct?
That's correct, Judge.
Okay. Don't you think the lack of a transcript may prove fatal to your position? Because I remember when I sat on the circuit bench, sometimes many people were on the record says this, but they show up and say, Judge, just push off a sale date for me. So there could be concession. We don't have a transcript, so we don't know what was conceded, what was agreed, what was done, did the judge consider. Doesn't that prove fatal to your position?
Well, no, Judge, because for two reasons. One, in how this court earlier this year agreed with my position following the 3rd and 4th districts, the transcripts are not needed for summary judgment rulings. And so that's the first point. And the next point is we preserved this issue with a timely motion for rehearing this specific issue on the absence of summary judgment evidence on mailing. Edmonds and Allen are right on point in this regard, and the issue was, and even without a transcript, I mean, it's prohibitively expensive to bring transcripts to every hearing in these cases, and so we don't need it here based on the Houck issue, especially when we preserved with the motion for rehearing the very issue I'm talking about on paragraph 22. Judge, they don't get to rely on a ceteris affidavit to say that a different predecessor servicer mailed the letter without any documentary evidence of mailing. There's no proof of mailing. Their affidavit says nothing about the boarding process, nothing about any routine business practice testimony. They just attach a letter from a prior servicer and say that the current servitor tries to say, well, here's the prior servicer's letter, it was mailed.
Well, let's backtrack, because there's cases from our court that basically says that all that the bank needs to do is just that they mailed. There's no requirement. I don't think we've come out and say that there has to be showing that the homeowners received the notice. You agree?
I agree with that. Okay,
right.
but 2 points there. First, the evidence, there has to be actually admissible evidence of mailing. You can't have hearsay statements to support the mailing. And Edmonds and Allen are both very clear on those issues decided this year that you can't, those were both in the trial posture, but in the trial posture, when the current servicer comes and has the letter and says, yeah, the prior servicer mailed this, but there's no mailing log or screenshot or documentary evidence of mailing, then the current servicer can't just say, well, the prior servicer mailed this without any documentary evidence establishing this. Now, the summary judgment rule 1.510 requires facts as would be admissible in evidence. So when you have the current servicer in an affidavit trying to say, well, here's the letter, the prior servicer mailed it, and there's no mailing log or return receipt or screenshot or any other document showing that it was mailed, and there's nothing in the affidavit that supports the boarding process either, and we preserved that objection via our timely motion for rehearing, then, and the Houck case doesn't even require transcripts of summary judgment hearings, there was an issue of fact with respect to the mailing of the letter. But in addition to that, Your Honor, in the reply brief, I cite 3 cases which stand for the proposition that the holdings of the cases, Banton, Kyrie, and Tawati, and this is an issue that this court has not yet addressed based on my extensive research on the issue, even though the requirement is only to mail, when you have an affidavit that shows non-receipt, the affidavit of non-receipt creates an issue of fact about whether the letter was mailed. So I'm not pointing to the affidavits of non-receipt to try to prove non-receipt. I'm pointing to the affidavits of non-receipt to say that that creates an issue of fact about whether the letter was actually mailed. And the decisions in Banty, Kyrie, and Tuati, the first and third DCAs, both clearly hold the holdings of those cases. They're all in the insurance context, okay? But that's really the only situation where this issue comes up is in consumer cases, because that's where there's contracts which say all that has to happen is for a notice to be given is for it to be sent. But in all three of those cases, the rulings were that when you have one side saying we sent a notice, or there was a routine business practice to mail notices, and the other side saying we didn't get the notice, that creates an issue of fact for mailing that has to be resolved by the trier of fact at trial. And so I understand, and this is what I submit as an often confused point, where yes, you only have to prove mailing, but you have two DCAs which have agreed with my proposition that when you have an affidavit that denies receipt, yes, it's not conclusive as to mailing, and this court did rule on that, reversing a defense summary judgment in Ostrander. I submit that the evidence on non-receipt isn't conclusive on whether it was mailed or not, and I'm not disagreeing with that proposition, but at minimum, an affidavit of non-receipt creates an issue of fact about whether it was mailed or not. So you have the lack of summary judgment evidence on whether the notice was actually mailed, as well as the issue of fact, which was created by our affidavit as to whether the issue was mailed, and that's only talking about the issue of paragraph 22. On the issue of standing, you have my opponent is relying upon an assignment of mortgage.
And before you get to that, Mr. Sopa, you're right into your rebuttal time. I just want to alert you to that.
Oh, okay. And I want to briefly touch on the bankruptcy surrender argument. I feel like I really did well with this in the reply brief, but their bankruptcy surrender argument is based on facts which are not part of the appellate record. That's clearly not allowed. It's based on a bankruptcy which was actually dismissed and no discharge was entered. Judicial estoppel cannot apply on that fact pattern. This court ruled that way in a case called ZEEUW in 2008. And Audrey, one of my two clients, did not even file that bankruptcy. So there was no discharge. It was only filed by one of my clients, and it's not part of the record. So there's no way that anything regarding bankruptcy precludes us from prevailing here today. So with that, I'll save the rest for rebuttal.
Very good. So you have about 4 minutes, actually 3.5 minutes for rebuttal, okay?
Thanks.
Very good.
Good morning, Your Honor. Amina McNeil on behalf of the appellee. The final judgment entered in favor of Fannie Mae should stand as we conclusively established that there was no genuine issue of material facts on the record
And
or...
Can I have you spell me your last name?
Yes, Your Honor. It is McNeil.
Very good. And you're with you're with the Gladstone Law Group?
Yes, Your Honor.
Very good. Thank you, ma'am. Please proceed.
Oh, I was saying, Your Honor, that essentially we established that there was no genuine issue of material fact that was raised in the record or that could be raised. In addition, although there is a heightened burden for summary judgment when the motion is filed before an answer, the heightened standard is not the same as the one being raised by the appellant. Nor was the standard meant to protect a non-moving party when said party chooses to willfully sit on any rights or defenses it may have. The heightened standard for summary judgment was contemplated to protect a non-moving party due to the shortened time period that has been allowed for a party to move for summary judgment. And that rule allows that a party can move for summary judgment after 20 days of the filing of the complaint. In this instant matter, the summary judgment filed by the appellee was filed over 2.5 years after the foreclosure was filed, and it was filed over 8 months after the defendant filed its amended motion for summary judgment and motion to dismiss. Looking at what we proved in order to foreclose the mortgage, we met all the prongs that are required under the law. We conclusively proved standing based on the evidence that was filed with the court in the affidavit of indebtedness in support of the summary judgment. We proved that there was a default. We proved that a notice of default...
Backing up just to standing briefly, how did FNMA establish its standing on the record that we have before us? Standing being one of these issues that plaintiff has to prove, apparently.
Looking at Fannie Mae alone, well, actually, let's back up to the initial plaintiff because this complaint was filed in the name of City Mortgage. So first looking at the complaint that was filed. Attached to that complaint was a note endorsed in blank from the original lender. There was a modification of the note and mortgage attached to that complaint. There was also a certificate of merger showing that the original lender had merged into a sitting mortgage at the time of the filing of that complaint. After Fannie Mae comes into the case, the original note and mortgage is filed with the court after Fannie Mae has filed an affidavit saying that Fannie Mae is the holder of that note. Because the original note and mortgage endorsed in blank was presented to the court and Fannie Mae says, I hold this note, all they had to do at the time that they were in the case and file that note was to be able to show physical possession, and by virtue of the fact that they filed an affidavit saying, I hold this note and I present this note to the court, that was enough to show standing as a holder under the Florida statutes. Picking back up, Fannie Mae also proved that the amounts that it was seeking were due and only by virtue of the summary judgment evidence before the court. And in terms of the issues of being able to rebut or anticipate any genuine issue material fact raised by the defendant, the affidavits filed did that as well. As the court has already pointed out, and that what we would like to reiterate is that the standard for when the motion for summary judgment is filed before the answer is filed by the defendant is not that we rebut or disprove any possible affirmative defense. We cannot use affirmative defenses in genuine issues of material fact interchangeably. They are not one and of the same. We only had to show that there was no possible genuine issue of material fact based on the evidence that we filed, and we believe that we did that. If we look at what the genuine issues of material facts could be, they could only flow from the prongs or the standards that we had to prove in our complaint and to be successful in foreclosure, meaning that they would have to flow, be some type of issue of fact as to standing, the notice of default, that there was a default, or that the damages that we asserted were in place. And none of that happened. Also, if we look at the case law that the appellant is relying on to say that we have to anticipate any possible affirmative defense, all of those cases say genuine issue material fact is the thing that we have to be able to possibly anticipate, and we did so. And if we also look at the facts of those cases, there were things on the face of the pleadings themselves, even if they weren't specifically raised, there was something in the pleadings that alerted the court that there could be an issue of material fact. For example, in the Jean-Jacques case that the appellant has relied on, the pleadings were inconsistent. The complaint was filed with one version of the note. The summary judgment evidence had a different version of the note. Even though there was no affirmative defense raised, because of that difference in what was initially requested from the court and then filed at the time of judgment, there is a possible genuine issue of fact that should have been anticipated. In terms of the issue with the affidavit itself, our affidavit was proper. The attestation by the affiant clearly fell within the business rule exceptions of paragraph 22. The affiant testified that all the business records that were attached in support of the motion, which included the default notice and payment histories, were kept and maintained in the ordinary course of business of Ceteris, that it was the normal habit of Ceteris to keep these records, and that they were made a part of the records at or near the time of the occurrence by someone with personal knowledge. We were not required to further assert anything to anticipate a boarding process argument by the appellant, and the evidence submitted on that affidavit speak for itself. Additionally, in terms of the notice of default, that was also properly attested to by the appellee in our affidavit. It is generally held that if you present a copy of a letter to the court, that per the standard business procedures is that there can be a presumption that it was sent, and that some rebuttal does not necessarily raise to the level to where the plaintiff, or the appellant now has to come back and submit additional proof that the letter was received. It's only that it was sent, and our position is that by virtue of the attestation to the business records exception, that was met.
Just to back up on that, help me understand your argument a little bit better. Are you saying that we just ignore the affidavit, that we didn't, that the defendants didn't receive this letter? Or are you saying that that's a qualitatively that is so low that it shouldn't even create a disputed issue of material fact? I'm not understanding your argument.
Let me clarify. What I'm saying, Your Honor, I believe is more in line with the latter of what you stated, is that although the defendants filed an affidavit stating that they did not receive the letter, an affidavit stating non-receipt is not enough to somehow shift the burden to the plaintiff to show additional proof of mailing. Well, I don't know that your colleague here would argue a burden-shifting argument as much as I think what the argument would be is that you've now not established your initial burden on summary judgment. All you've put into for summary judgment record is we sent a letter. The purported recipients of the letter have testified by affidavit, we didn't get it. Therein is the dispute, go forth and have your trial. I think that would be the position, is that evidence necessarily means you haven't established your initial burden of proof, not that it necessarily moves the burden of proof back to you. I don't know. What are your thoughts? I mean, my thoughts as I read, or as I understand the appellant's argument, is that in order to just even meet our initial burden of no genuine issue of material fact, we had to state more than that we mailed it. And we do not agree with that. Our position is that under the terms of the note and mortgage, all we have to do is mail it, and that we properly asserted that we mailed it, and we attached by virtue of the letter the proof of mailing, and that proof of mailing is all that there is needed to show that that event or that condition precedent actually occurred. So we do disagree with.
And that there can be no dispute that fact occurred.
Well, granted, by virtue of...
That's what summary judgment is. I mean,
Right.
it says that there's nothing to decide here.
I would say that how do I say this correctly? Just because it is raised by the appellant, we disagree doesn't necessarily meet the...
I get what you're
Right.
saying. Look, if this goes to trial, we're going to blow them out of the water. We're going to have a witness that's going to say it was sent, and all they're going to be able to say is, well, we didn't get it, and we all know how the finder of fact will shake that out. But that's what we have trials for, right? I mean, that's the part of this case that's bugging me a little bit, is this notion that we now have, based upon an affidavit that says we sent a letter, and which is a requirement in this foreclosure, and then an affidavit said, well, we didn't get it. We're just going to ignore that other affidavit. It doesn't really mean anything. No need to have a trial on this issue, and I'm not sure that's where the law is on 1.510.
I understand your Honor's point. I do believe that we cited some case law, the Brown case and the W.T. Holding case, in our brief to also back up our position, but I do realize that it may be something that the court has to wrestle with in ultimately deciding did that create an actual genuine issue.
Did it?
Oh, excuse me. I guess.
I'm sorry. I thought Judge Valenti in one of our opinions addressed that, and I can't seem to pull it up, that just simply say that they didn't receive it doesn't, for lack of a better word, doesn't cut it. But I just can't pull the case right now. I'm sorry, go ahead.
Well, I was going to, a similar type question is it the absence of receipt, or is it a challenge to your claim that it was actually mailed? So would the evidence that the homeowner would have to present would be just, I didn't receive the letter, or somehow show some sort of evidence that would create a factual issue that disputes the fact that you actually, whatever process that was used was actually used to mail the letter?
I believe that they would have had to assert something that directly challenge our assertion that it was mailed, and simply saying non-receipt is not enough to do so. And if we were at the trial level, them coming into court and somehow proving that they didn't receive it would not be enough to overcome evidence of mailing. And that's my understanding of the current state of the law when it comes to mailing, that, because non-receipt is not required under the mortgage, it's just the mailing. And so you could say you didn't receive it all day. That still doesn't address the issue of whether or not it was mailed, and non-receipt is not necessarily an indication that the letter was not mailed. I'm sorry, I lost track. Looking at the payment history, which I believe that is also touched on briefly in appellant's brief, it's the same argument. We do not agree that there had to be some type of additional.
So let's go back to the proof of mailing.
Yes,
Help me show me where that it shows that there was proof of mailing in this case.
Our position is that by the letter in and of itself, because it is dated, it has the mailing address on it, it's saying that it's essentially being sent to give notice of the default, and that it's done in the normal course of business. That is in and of itself enough to show that the letter was sent under the theory that general business practices as to the sending of correspondence is enough to establish mailing of any correspondence or documentation. So that is what we're hanging our hat on, is that case law that says that if it's the normal course of business to send such letter, and this letter is kept and maintained in the course of business, then that is enough to establish a sending of the documentation.
So we generate a letter, it exists, therefore it must have been sent?
We generated a letter, it's kept and maintained in our normal course of business, and it's the purpose, this letter is created for the purpose of sending out to give notice.
We have testimony, do we have an affidavit witness testimony says this letter was sent?
We don't have, the affidavit does not specifically, I want to make sure I state correctly, because I do have the affidavit. The affidavit doesn't specifically say, I, affiant, sent out this letter, but
Right.
the affidavit does say that the letter was sent.
Okay.
Yeah. Similar argument with the amounts due and owing. The summary judgment evidence attached to the affidavit speaks for itself. It shows all the payments made, the type of payments made, payments coming in, payments going out, payments for escrow, payments applied to principal and interest. It even reflects that there was a servicing transfer, which is something that the appellant has brought up in his brief. It's properly attested to as being a part of Soteris' business records. Therefore, Soteris could rely on it. The fact that it exists, the fact that it's a part of its business records conclusively shows that they did rely on it under all the case law for business records maintained by not only the servicer, but for the prior servicer. Therefore, again, there's no genuine material issue of fact created to that, and there's no additional testimony from the affiant that has to be put forth in terms of the boarding process to support them relying on it and for it being a part of its business records. Additionally, we know by the terms of the very note and mortgage itself, where the bulk of the damages come from. We have to remember that the note and the mortgage is the first place that we look to in order to determine how principal and interest is accrued and accounted for with the life of the loan. So if there was even any question whatsoever as to any figures, we would state that it would not rise to the level to reverse the entry of final judgment, maybe possibly change the amounts due and owing that were found in the final judgment. I believe that in terms of we did in our brief address the bankruptcy surrender. I would just point out for the court that after our brief was filed, that the appellant did dismiss the bankruptcy, and there was not any discharge entered by the time that dismissed. So I kind of think that argument is moot by the fact that they withdrew their bankruptcy. Are there any additional questions? I don't know how much time I have left, but,
Further? Anything further? Very good. Thank you,
all
ma'am.
right, thank you, Your Honor.
And Mr. Stopa, you've got 3.5 minutes, sir, for rebuttal.
Thank you. The entirety of the evidence on mailing is in paragraph 6 of their affidavit, and the use of passive voice is telling. The borrowers were properly sent notice prior to acceleration. Now, this is a ceteris witness who is purporting to say that a city employee sent the letter without any documentary evidence showing that the letter was mailed, such as a mailing log or return receipt, which is what this court required in this year in Edmonds and Allen. That's what this court required, is if a current servicer is going to say a prior servicer sent the letter, there has to be documentary evidence of that, or there has to be competent, substantial evidence of that prior servicer's routine business practice, which is predicated on personal knowledge. And here, you don't have any routine business practice testimony. You don't have anybody saying what city's procedures were for mailing letters. So their argument is just the way, I love the way, Judge Lucas, that you asked the question. The letter exists, therefore it was mailed. That's essentially the position that they take in the affidavit. And the problem is that this court specifically rejected that very argument in both Edmonds and Allen cited in our answer brief. So there is no summary judgment evidence showing that the letter was mailed at all. So just that is one of the issues of fact that they did not disprove. Now, also...
Which leads me to then, I go back to this lack of transcript. There was a hearing. We don't know what was said at the hearing, what was done at the hearing, what things the court was handed. We don't know any of that, Mr. Stopa. Is that a hindrance to your position? Because I know what the affidavit said. You're correct. This is what the affidavit says, but I'm concerned with the lack of transcript.
Judge, Howe ruled this year on that issue. The lack of a transcript is not fatal. I could understand that a bit better to the extent of making an evidentiary objection if there was nothing at all in the record, but our motion for rehearing specifically addressed this exact evidentiary defect. So you have something written in the record which shows, hey, they didn't do this the right way, and you have this court saying you don't have to have transcripts of summary judgment hearings. Now, I also bring you back to the Mitchell decision. In Mitchell, this court specifically held, I can read the quote here, that it reversed a summary judgment pre-answer because the plaintiff had not, quote, negated conclusively the defendant's possible defenses. Negated conclusively the defendant's possible defendants, end quote. That's this court in Mitchell. Now, I essentially dared my opponent to present some contrary case law on that issue. They didn't present any. So this court in Mitchell does require, consistent with what I was arguing earlier, that they have to disprove not just any genuine issues of material fact, but any affirmative defenses that we might be raising as well. That clearly didn't happen. Also on the mailing issue, Your Honor, the case you were just thinking of with Judge Vellante was Ostrander. But in that case, and that's at 201 Southern 3rd 1281, but in that case it was a defendant summary judgment which was granted based on an affidavit of non-receipt. And what this court said is that the affidavit of non-receipt did not conclusively prove the non-mailing such that a defendant was entitled to summary judgment. A defendant doesn't win summary judgment based on proof of non-receipt. Okay? But that's not the question here, and this court has not addressed the question of, well, even if the plaintiff had proven mailing, when we have an affidavit that says we didn't get it, this court hasn't addressed whether that creates a factual issue. Okay, that question hasn't been resolved. But I've given you Banton, Kyrie, and Tuati, where the first and third DCAs have both held that an issue of fact is created when there's an affidavit of non-receipt on whether the notice was mailed. Here's how I like to think of that. Is an affidavit of non-receipt relevant? Would it be relevant at trial? Relevance is a very low bar. Is it more likely than not if you don't get a notice in the mail that it wasn't sent? I think the answer to that question is unequivocally yes. It is more likely than not if you didn't get a notice in the mail that it wasn't sent. It's not conclusive. Okay, it's not conclusive because maybe it was lost in the mail or maybe there's some other explanation. But is it more likely than not that a notice that you don't get was not sent? Yes. Once you accept that it's relevant evidence, at the summary judgment stage, you must weigh everything in the light most favorable to us. So accept that that's not relevant. That necessarily means that summary judgment, that creates an issue of fact on the issue of mailing. And that's why you have those three cases which have held that an affidavit of non-receipt creates an issue of fact on mailing, and I submit you couldn't rule against me without certifying the question.
Well, Kyrie was actually a directed verdict. issue, wasn't it?
But all three cases were concluding it creates an issue of...
Same
Yeah.
basic thrust.
They're all, I think Banton and Tuatse were both summary judgment posture, but all three cases are holding that an issue of fact gets created on the issue, and that's the point. And so I submit it's clearly relevant, and so once there's a factual issue, we have to win on all of the factual issues. I also submit on standing, the appropriate question isn't just what's the proof that Fannie Mae was the holder, and I submit they did not prove an agency relationship for constructive possession under the Fan decision that Your Honor wrote, but also what's the proof that Citi was the holder at the inception of the case. There isn't any proof that Citi was the holder at the inception of the case either. They're apparently relying entirely on what I call the Ortiz presumption, but the Ortiz presumption doesn't apply when there's a substitution of party plaintiff during the pendency of the case. Think of it this way. All you have here is an affidavit from Ceteris that says that Fannie Mae is the holder as of the time of summary judgment. Where's the summary judgment evidence that Citi was the holder at the time the suit was filed? You don't have any. They're only relying on the copy of the blank endorsed note attached to the pleading, and that's not sufficient when there's a substitution of party plaintiff during the pendency of the case. They have no case law to support that proposition.
Okay, Mr. Stope, I was waiting for you to take a breath so I could tell you run out of time, but you kept going. So.
And I was trying to not breathe so that you wouldn't tell me that,
All
Judge.
right. All
Thank you
right,
very much.
Good. Thank you, sir.